All right, good morning or good afternoon. There seems to have been some problem with the link that we sent out. Thank you for all figuring out how to get in here. This session is being recorded, as you just heard. People can watch it later. I apologize for anybody who obviously isn't on here, but listens to this later that somehow this got messed up, and unfortunately the people who know how to fix it aren't here. So we will proceed as if everybody's here as best we can. Okay, so we are here on the medical claims this afternoon. This morning we did a session on general introduction to representing prisoners. For anybody who's on now but was not on this morning, I want to spend just a couple minutes repeating some of that, so sorry if this is repetitious. There are resources beyond what we're going to do today. We don't expect you to remember everything we talk about today. The idea of this particular seminar is to make it so that you have some basic idea of a roadmap as to how you can get from, gee, I just got assigned to this case, to settlement or to trial. There are lots of resources, both on the Northern District and Southern District websites, as well as on the Uptown People's Law Center website. There is also a listserv. The link for that is in the materials that were sent out earlier. It is hosted by the law firm of Kaplan and Grady. It's a great place to ask questions, get model pleadings, or see if somebody else has deposed somebody, so you have that basic information there. So there are other resources available, and on an ongoing basis, I am also available to answer questions as you go through your case. My contact information is also in the materials that were submitted. So why do we have a separate claim on why do we have a separate seminar on medical claims? Because for two reasons. First of all, they are probably the most numerous claim that is filed in the federal courts. Illinois has among the worst medical care systems in the country, according to the experts that have been working on this issue. Not that others are great, but Illinois is particularly bad. So it's not surprising there are a lot of those lawsuits filed. It's also the sort of lawsuit that often has its own challenges, particularly for appointed lawyers. It's not like you can go out and you have unlimited resources to hire an expert. So part of what we're going to do today is what you might be able to do either to narrow what you need as an expert or to avoid getting an expert altogether. And perhaps if you need an expert, how you might be able to find an expert aside from using the listserv, which is also a great way to locate some experts. So the legal standard here that we're going to be dealing with for medical claims is deliberate indifference. And basically that's a combination of objective and subjective standards, which we'll talk about a lot more as we go forward. But the bottom line is it's a step beyond medical malpractice. So just showing negligence is not going to be enough in these cases. It's a start. You have to be able to show negligence. Obviously, if you did everything right, then you haven't got a claim. But it goes beyond that. There has to be actual awareness of the harm or the risk of harm to the client, as well as a deliberate decision not to do something that is relatively easy to do, which would have fixed the problem. And we'll really play that out a lot more as we go through the afternoon. But that's sort of the basic outline of why there's both an objective and a subjective component to this, which makes it a little more difficult. Typically, these claims fall into two buckets, which overlap. One is improper treatment. That is somebody got some treatment and it just was screwed up. And probably even more frequent is the delay in treatment. Somebody reported a problem and it took them months or years to actually get the treatment they needed. So delays in treatment, I think, are by far the most typical case. And often you have both. Often you have a long delay and then something went wrong, so you got bad treatment, and it was even longer before they got the appropriate treatment. Sometimes you have a failure to treat at all. So by the time you get the case, they still haven't been treated, at which point you're going to think about getting adjunctive relief or perhaps even emergency preliminary injunctive relief to deal with the immediate problem. I also want to talk about competence here. Lots of lawyers get these cases and say, hey, I've never done a medical malpractice case. I'm a patent attorney. I don't know anything about this. Well, under the rules, particularly in the Southern District, competence is not a reason to withdraw. Both the Northern and Southern District understand that people have not had a lot of experience representing prisoners and may not have had a lot of experience doing medical claims. But that's why I'm available. That's why the resources on the website are available. So you have an obligation to obtain the necessary substantive expertise. And both Northern and Southern District talk about that. The Northern District has some very specific rules as to how you can gain that expertise by attending this seminar, by volunteering on other sorts of help desks that you may have more familiarity with. But in the end, this is an obligation that comes with being admitted to the bar and having the privilege of practicing in these courts. And therefore, I strongly urge you to take these cases on. You will never find a more grateful client than the clients that you do a good job for here. So they're kind of fun cases too. I mean, many of us went to law school thinking about great constitutional claims they're going to bring and arguing for the Supreme Court and all that. And most of us end up not doing that. Well, here you get to litigate a constitutional claim. These are Eighth Amendment claims under the United States Constitution. So you get to litigate some constitutional claims. One of the reasons there's so many cases is because there are a lot of people who are disabled in prison or have serious medical conditions, and it's way higher than it is in the general population. So asthma is about twice as prevalent in state prisons as it is among the population at large. Hepatitis B is about 3 times as prevalent in the prison system. Hepatitis C even more so. HIV or AIDS also almost 3 times as prevalent inside prisons as it is outside. So there are lots and lots of very sick people who have very serious medical conditions in prisons, and they're not being treated. Same is true of diabetes, and it's growing. So the severity and numbers of these conditions are all growing, even among state prisoners. So again, we have hepatitis, we have asthma, we have hypertension. Sorry. There's noise going on next door, which I'm trying to get rid of. So again, there are lots of sick people, and some of these are, like diabetes is generally easy to control if they get the right care. If they don't get the right care, then it can become a very serious and life-threatening disease. So consistency and paying attention to it and individualizing care is what's really crucial in managing many of these diseases, and it's one of the hardest things for prison systems to do. They very much like to have a rule that applies to everybody. Same thing is true with mental health issues. There are a lot of very seriously mentally ill people in the Illinois Department of Corrections and in every other prison in the country. And most of them don't get treatment. So 56% of the people who are in a prison have some history of mental health problems, but only 26% of the people in prisons have gotten help since they've been admitted to the prison. And only 6% of them are currently getting help when they're in prison. So again, this is a category of disease which is vastly undertreated in our prison system. And by the way, the 56% here does not include 2 of the big ones, does not include substance abuse, and it does not include antisocial personality disorders, which some people would say account for probably 90% of prisoners if you add those to it. And even some of the more serious of the mental disorders, which include bipolar disorder, PTSD, schizophrenia, all are vastly more common in prison than they are on the outside. So it's often defendants will say, well, people get better medical care in prison than they get on the streets. Well, 2 answers to that. One is they need a lot more medical care than they get on the street. And the second is the Constitution provides that they have to be given medical care in prison, whereas people on the outside do not have a legal right to medical care. So therefore, the idea that somehow the fact that there are just as many doctors on the inside as there are on the outside is not a defense to anything. So we want to use not a hypothetical, because it's a case that Nikki actually tried, but just to talk about how some of the difficulties arise. So I want Nicole to sort of go through this, and I'll start it off by saying it all started with a paperclip.
It did all start with a paperclip and ended with a jury trial with a $400,000 verdict. So our client in this case is Anthony Rodeski, who was at TAM Supermax prison, which was a closed security, high supermax prison. He had no access to outside people, outside world, very limited access to certain kinds of property. Mr. Rodesky was in this cell almost every day, all day. Once in a while, he'd get out to a yard that wasn't much bigger than this cell. So he spent a lot of time pacing back and forth. Mr. Rodesky had type 1 diabetes, had it for years, insulin dependence, and he had special shoes that he had gotten as part of a medical permit to protect his feet being diabetic. However, during a shakedown, a paperclip was found in his sneakers, which was not allowed at Tam's, and his sneakers were taken away.
Not
And
only did they take the paperclip, they took the shoes.
they took the shoes, right? The shoes were taken away, and he got issued new shoes that have limited support, the kind of general shoes that are given out to every prisoner in custody. That he had to purchase the sneakers that he had taken away. So these flat shoes, he got given a size 13 when his foot size is a size 6. So they clearly did not fit him. He's had a lot of time to just sit and pace back and forth, nothing else really to do in those cells all day long. And he eventually developed a blister on his foot. For those of you who don't know, any kind of injury or sore on a foot with a person with diabetes is really dangerous because the diabetes affects the way the blood flows. And this is specifically problematic for Mr. Rodesky because the prison was not allowing him to keep his diabetes under control. During this time period, his blood sugars were, around 300 to 400 levels. It's bad if things get over 200 levels. And in prison, a person can't, like, the doctors will say, go exercise, eat better. Mr. Rodesky couldn't do that. He couldn't go exercise. He couldn't go out for a jog. He couldn't go weightlift. The food he was served was the food the prison gave him. If he got served tacos that day, he had to eat tacos. If he got served hamburgers and french fries, he had to eat hamburgers and french fries. He didn't have the option to eat fresh fruits and vegetables like people in the outside world did. And so these sores on his foot were even more dangerous than anyone on the outside could imagine. He went to the doctor. They gave him Silvadene cream, which Mr. Rodesky was actually allergic to, and they knew that he was allergic to. So the wounds did not get better. They just got worse, and they got worse, and they got worse. And eventually this small blister on his foot from wearing the shoes that did not fit that were issued to him by IDOC became a bone infection. At this point, he is placed into the healthcare unit and actually gets some decent care from an outside medical provider. But this took a year before he got to go see a medical provider who was a specialist and knew how to handle bone infections. Pieces of his foot were cut off to try to stave the infection, and that eventually did work. And around towards the end of 2012, Mr. Rodesky was on the mend. He was still not weight bearing. He couldn't put any weight on that foot, but he was close. Then Tam's closed. And
And
Mr.
clear, he
Desky
spent
gets
to be clear, for the last several months, he spent in the healthcare unit bedridden.
correct. He gets transferred to Pontiac Correctional Center on a busload with the other guys from Tam's. To get on the bus at Tam's, he was taken there in a wheelchair. He gets to Pontiac and he's forced to walk off the bus himself. He asks, "Where's my wheelchair?" They say, "We don't know. We don't have any paperwork." We found out that there was paperwork. Every time a person is transferred, a little note with their medical conditions is transferred with them, and the prison is supposed to get that ahead of time. He's forced to walk off the bus, walk across the large campus to the cell house that he's eventually placed in, and he is placed on the third floor, 5 gallery here in this picture, which means he had to walk up 2 flights of steps. He hadn't walked up steps in years, and now he's forced to do this. He alerts everyone he can think of to alert that this is a problem for him, and no one does anything about it. He puts in requests, he puts in grievances saying, "I can't be at this high gallery." What do? They move him up to 7 gallery, even higher, saying that it's a low gallery for some reason. um, and so maybe this wouldn't have been so bad and he could have healed, except for the fact that every day, twice a day, he had to walk down to the first floor, so 3 flights of steps, to get his insulin shots. And because of that, wound reopened and became much worse. At one point, his cellmate during this time period told us it smelled so bad that no one could, like, he could smell it from anywhere in the cell. It was getting gangrene, and Mr. Rodesky again files grievances, raises the issues with the doctor, and nothing happens for several months. He tries to get moved down to the first floor gallery at least, so that he doesn't have to walk those stairs, which at this point he's basically crawling down, and nothing happens for several months. Finally, the doctor at Pontiac sees Mr. Rodesky and issues an actual new low gallery permit. Several months pass, and Mr. Rodesky's finally moved down to the low gallery. He is sporadically sent out for outside care for this infection that is very clearly serious. Eventually, he gets moved to the healthcare unit and receives some care. But this goes on for 3 years. At one point, Mr. Rodesky's had enough, realizes that nothing's gonna change. He's been living in this kind of pain for half a decade. And his specialist at UIC says, there's one way to fix this, we can amputate. So Mr. Rodesky, instead of going through months and months, years and years of more excruciating pain, not being able to move around at all, decides to go with the amputation. And that's the case. That's the facts of the case. When this gets up to trial, there was a lot of stuff going on. There was all kinds of.
Take a pause here.
Oh.
We'll get to the trial in a minute. So it seems to me the difficult part is, who do you sue? So many things have gone wrong here. It's not clear who's responsible. And that's a big problem in these medical cases in general. The responsibility for care is, I would say, intentionally spread among so many different people. And then on top of that, you have the security people, because doctors don't actually assign cells. They just write a note saying you should be on a low gallery. And the Department of Corrections is the one who says, well, 7 galleries is a low gallery. So is it the guard who put him up there? Is it the warden? Is it the director? Is it the doctor? Who do you sue? And that is often the most important decision you can make in these medical cases, is figuring out who is responsible. Because remember, if you're here this morning, there is no respondeat superior under Section 1983. So you can't sue like the head of the medical department saying, hey, they should have known what was going on. They did this badly. You can't sue the state of Illinois saying they ought to have a way to deal with medical permits so that they're not on the third floor. But you can't sue those people because they're not the ones that are actually directly responsible. They're the ones who are in charge of the people who are responsible. So often the trick is figuring out who it is who you're going to sue. And we want to talk here for a minute then about how medical care in the Department of Corrections is arranged. And I have to say here, the way that we're setting this up is based on the way that Wexford had it set up. But I want to be clear that Wexford, as of the end of July, I think is right, no longer is providing the care for the Illinois Department of Corrections. Instead, there's currently an interim contract by a company called Centurion. So it's still a private corporation providing it. But as far as I can tell, at least as of now, they have yet to change the structure. So the basic structure is going to be the same, at least for a while. But do be aware that if you have a claim both for injunctive relief, that is, you want to get treatment going forward, and a damages claim, you may be suing two different sets of entities here. Wexford for what happened until July, Centurion for what happened after July. So with that understanding or that warning, let's talk about how the medical system is set up in Illinois. Again, there is a private corporation, formerly Wexford, now Centurion, which is contracted by IDC to provide medical care to all prisons across the state. There are a couple of minor exceptions for like particularized drug units, et cetera, but 99% of the medical care is provided by Wexford's an outside company that's hired to do that. Wexford has layers, as you can imagine. There's a state director, there are regional medical directors, north, central, and southern. Each prison has a medical director. Then there are doctors. Many prisons only have the medical director as the only doctor. Some of the larger prisons, at least in theory, should have several doctors. And this is the way it's supposed to be set up. I have to say in theory, because we currently have pending in our class action case, a motion asking the court to find them in contempt of court because they are vastly understaffed right now. So some prisons that ought to have 3 or 4 doctors only have one part-time doctor. So again, there may be other doctors, but there may also only be a part-time medical director. And then there are nurses and other personnel that are hired by Wexford. There's sort of a parallel system by the IDOC. So the IDOC itself has a medical director, and it has regional medical directors. There's a healthcare unit administrator at each prison, and then there are some pharmacy techs, and a few prisons still have state employed nurses. But the key is that none of the people who work for the IDOC actually have the authority to tell the people employed by Wexford to provide any kind of particular care. Their job is much more to administer and make sure that Wexford is in fact following the contract rather than to tell them what to do. So the healthcare unit administrator, many prisoners think they're the ones that are in charge because they're the ones that respond to grievances. But in fact, the healthcare unit administrator is typically a nurse and has, even in the outside world, but have no ability to tell a doctor what to do, and in prison has absolutely no authority over what doctors do. So often you're dealing with somebody who's employed by Wexford. You'll be able to tell who they're employed by, who is representing them. Wexford employees are all represented by a private law firm, and IDOC personnel are all represented by the Attorney General's office. In addition to all of those people, there are also outside providers. So Wexford provides any of the care that can be provided within the four walls of the prisons, but anything that requires a specialist or specialized equipment has to be sent outside for care or consultations. The vast majority of that is done by the University of Illinois in Chicago, which has a contract with the IDOC that they'll provide X number of dollars of care, sort of for free. There's no extra cost to that. And then if they go beyond that, they have to get paid for it. And then there are lots and lots of consultants, specialists on the outside that aren't employed by Wexford because there's not enough demand for them. And that can range anything from orthopedic surgeons or brain surgeons all the way down to like orthopedics, ophthalmologists who deal with eyes, audiologists who test hearing. So there are lots and lots of these outside consultations that occur. That's who provides the care. Now, how does it get provided? Well, the vast majority is through sick call. There are two other things that happen. There's intake when somebody first arrives at a prison. Excuse me. Either because they're newly convicted or because they get transferred from one prison to another. There is an intake assessment that's done. Now, that is not a thorough physical exam. That is much more a, what are your problems? Are you on any medication? See you later. So it may last less than 5 minutes. There are also some chronic clinics where people automatically get sent to the doctor every 3 or 6 months, depending on the nature of the clinic. Not all what we think of as chronic conditions are covered by this. Instead, it's very limited. Like there's a diabetes clinic, there's a kidney clinic. I'm sure there's some others which I'm not remembering, but there's probably half a dozen of these sort of people who are automatically set up with appointments with doctors on a particular schedule. Everybody else gets to see a doctor by going to sick call. It's kind of like making an appointment with your own doctor, but not really. There's a slip you fill out, which is called a sick call request, or something like that. And you literally write down your name, your number, your location, and what it is you need to see a doctor about. Once a day, those are picked up from the unit, taken to the healthcare unit. Somebody at the healthcare unit goes through them, figures out who needs to get seen right away, who can be waited, and who doesn't need to be seen at all. And then they're scheduled to come in. A list is made up, the list is given to the guards. The guards have to go to the cell and pick people up and walk them over to the healthcare unit. When they get there, though, they don't see a doctor. They see a nurse. Nurses, by law, can't diagnose and prescribe on their own. They can, however, do what are called using protocols. So both Wexford and I'm sure now Centurion, as well as IDOC, have their own protocols for each sort of complaint. So to use a sort of silly example, which is not an actual protocol, to be clear, you walk in and your back hurts, and they say, well, take 2 aspirins, go away. If it doesn't resolve, then come back again. Then you have to go through the sick call process again, to go through the triaging process again, get a second appointment. Again, you get to see a nurse. And the nurse will look at the sheet of paper, which says, okay, second time they come, you give them the sheet of paper of physical exercises you do. So you're given that sheet of paper and say, well, keep taking the Tylenol and then go back to your cell and do these exercises. If it doesn't resolve, then come back again. Doesn't resolve, you have to go through the sick call process, go through the triage process, get an appointment, hope that the guards come and get you. And then on the third visit, you'll probably finally get to see a physician who may actually make a diagnosis. Now, the problem is, again, when you get to see that physician, they have a unwritten one problem per visit rule. That is, if you wrote down on your slip of paper that my problem is I have a blister on my foot, taking Mr. Rodesky, then they'll deal with the blister. But if you say, hey, and I'm not getting the right quantity of insulin, they'll say, sorry, that's not why you're here. Start the process over again. You got to start all over again. So unlike in the real world where even on an HMO, you have a physician who's supposed to be responsible for coordinating all these specialists and figure out what your overall healthcare needs are. In this case, there's nobody who ever looks at the whole person and says, okay, you've got these 5 problems. This is how they interrelate. This is how we're going to come up with a program to deal with all these problems. It just does not happen. So that is sort of the routine that can go on here. And this is often not a quick process. It's not like you get to see that physician after 3 days. This can take months to get all the way through this process. Let's say you finally get to the physician, they say, and I want to be clear, not everybody goes through this. So if you walk in there with a broken bone, you're going to get seen right away. And in fact, the nurse can call the ambulance and you're taken to an outside hospital right away. But for the more typical medical claims you're going to have, where it's sort of, you're feeling pain, but you don't know what the actual problem is. It's something going on, but you're in pain, or you can't urinate, or whatever it is. You're likely to go through this process over and over again. If you finally get to the doctor and they say, "Oh, I don't know enough here. I need to get some outside consultation," under the old procedures, that had to go through several different steps. The treating doctor, whoever was examining you, has to make a recommendation to the on-site medical director. The medical director then has to send off a request to what they call the Utilization Review Committee, which is a Wexford group or Wexford individual sitting somewhere in, I think, Pennsylvania, who looks at it and says either yes, we'll agree to authorize an outside provider, or no, we need more tests, or we need to try conservative treatment, or we need a second opinion. And again, that loop can go on for a long time. Now, because of our class action lawsuit, they're not supposed to be using the Utilization Review Committee anymore. That formal process does not exist. However, they still do need permission to send somebody on the outside because they have to get paid. And therefore, there has to be a voucher of some sort that comes with that. So there's still some sort of review, but it's not the same sort of formal review. And often they'll label it in the medical records as a consultation rather than an actual asking for permission. And again, there have been cases where this loop has gone on for years. I know there was a case which I think somebody on this training here handled, where they were sent out to various ophthalmologists for years and ended up losing an eye because they kept being told, no, this is beyond my capability. He needs to see an eye surgeon. And by the time they finally sent an eye surgeon, which was many years down the road, he had actually lost the use of his eye entirely. So this loop can go on for a very long time. That's often the cause for many, many delays. There's a question which is what happens if people come with a pre-existing condition. Does not matter. Again, as long as they're aware of it, they have an obligation to treat it, and it should be the exact same thing we're talking about here. Again, whether or not they believe what you say, or whether or not they go back and actually get the records from the outside doctor is a whole different question. But the legal obligation is exactly the same, whether it's a pre-existing condition or something that happened when you were convicted, after you were convicted and after you're incarcerated. There's also a related question is, do they get the medical records? Because most people come in from county jails and got some treatment in county jails. Do those medical records follow them? The answer is not necessarily, and often not at all. The transmission between Cook County and the Department of Corrections has improved significantly recently. So those records do get there, but if they're coming from any other county in the state, it's a toss-up as to whether or not they're going to have those records at all. And certainly if they got treatment by an actual outside doctor, like when they're on the streets before they're arrested, that those records are not going to be automatically there, and you're probably going to have to get a loved one. If you're a prisoner, get a loved one in order to actually get those records from the original doctor and provide them yourself. And yes, it still takes just as long to get the doctor to answer a question in the Q&A. Illinois, as I said before, is among the worst. When we started our class action lawsuit, and up until like 2015, which is the last good data we have, Illinois was when we started our lawsuit earlier in 2015, Illinois was, I believe, 49th among the 50 states in how little we spent on medical care. By 2015, after we'd been litigating our case for what, 5-6 years at that point, we had clawed our way up, so we were like 10th from the bottom. But the difference is significant still. And at this point, Illinois is spending $3,600 per prisoner, and California was spending almost $20,000 per prisoner. And I want to be clear, California was not some Van Halia where everything was perfect. California is the state in which the United States Supreme Court said the medical care was so horrific that they couldn't solve the problem, and the only solution was to send people home. So California's at $20,000 a year was providing unconstitutional medical care. You can imagine just how bad Illinois medical care was at $3,600 per year. So we vastly underspend compared to most other states. I mean, people like Alabama are below us, although they now have a class action case going as well, so they may be moving up on the list as well. So there are, and Arizona similarly, which is below us, has a class action case pending, and has actually gotten an outside monitor appointed to not run the system, but to oversee the system. So again, it's not surprising Illinois provides really bad care. When I talked about understaffing, you have at least one doctor who's covering 5 different prisons in Southern Illinois, including Menard, which is our largest prison. So it's not surprising if they can't actually provide medical care. So not necessarily that you have incompetent doctors, although to be clear, there are some very incompetent doctors in the system. But even a really good doctor would have a very hard time dealing with, as the one example here is, over 6,000 people as his patients. There's just no way you can do that job. The mental health care side is just as bad. These figures are a little out of date now, but the IDOC back in 2019 said they needed a total of 516 mental health staff. By the time we got to court and had a court order entered, they only had 351, so they were significantly below the numbers of people they needed to do with mental health care as well. So it's not surprising that, first of all, it takes a long time to see a doctor, and second of all, that doctors don't do a great job because they have way too many people that they're responsible for. And also, to be clear, it's not that they don't hire doctors. They hire a fair number of medical people, but they leave. So while I use the bucket analogy, while they're continually pouring water on the top of the bucket, just as much of it is running out. In our medical class action case, even though they said at the relatively early on in the case they needed over 200 new medical people, in fact, over the course of the last 10 years or something like that, we have 1 fewer than we had when we started the case of doctors. So again, they've hired a whole bunch of people, but even more people have left. So there's not been a net increase. What this means, in particular in the mental health care side, is that people get very generic care. At one point, and it continues to today, but not quite this bad, the vast majority of people at Pontiac Correctional Center, which was the maximum security prison where we put the most serious mental health people, the vast majority of their so-called mental health treatment consisted of watching a movie. So 70% of all mental health quote treatment in big quotes was to watch a movie. And these are not like movies that are designated about mental health care. They're just popular movies. Now, as our expert says, or the court monitor says, movies are helpful. Anything that gets somebody out of their cell is helpful. If you're severely mentally ill and you're stuck in a cell doing nothing but staring at the walls all day long, you're going to get a lot worse. If you get out of your cell for 2 hours and go to watch a movie, it'll make you better. But that's not mental health treatment. It's not going to solve the underlying problem. It's good for people. It makes them feel a little less terrible, but it's not the problem. Not going to solve the problem. So that's kind of the problems we have in our system. is that badly off. So the sorts of claims that we can bring. You could sue the private medical provider, Wexford. You can't sue them, at least under the Eighth Amendment, because they're in charge. You can't sue them because they're the employer. Again, there's no respondeat superior here, so you can't sue Wexford because they're in charge. They're the ones who employ the doctors who are screwing up. You could sue Wexford if they have a policy or practice that actually caused the harm there. And there's a en banc Seventh Circuit opinion, Dean versus Wexford Health Sources, which goes through in great detail the sorts of evidence you need in order to hold Wexford liable. So if you're thinking about adding a policy claim, saying Wexford has some policies, they're the ones that cause the harm here, you have to read Dean because it gives you the outline as to how to do it. I have cited in the materials here that there is one Seventh Circuit case, Shields versus IDOC, which suggests that there should be respondeat superior against Wexford, but it is only dicta, and it has never been adopted by the full court, and therefore it's there if you want to cite it. I know some people have brought that claim in the alternative and dropped the footnote saying it is not current law, but if one Seventh Circuit judge says it ought to be the law, then I think that's enough to satisfy your Rule 11 obligation, that it is a reasonable chance of going there. So I know that we have often pled that in the alternative, that Wexford is responsible under respondeat superior as well as under no claim. The citation is in the materials, but it's Shields versus IDOC. I'm sorry, the two different cases. Dean. I don't have the full citation for it. It's a 2021 case decided November 10th of 2021. Dean versus Wexford Health Sources Inc. So the big question is whether you want to bring a renewal claim. Nikki, do you have any thoughts on when you want to bring a policy and practice claim against Wexford and when you don't?
I mean, I hate bringing them. They're complicated, they're hard to prove, but I also think they're worthwhile because if you don't, it, the same thing can happen all over again and continue to happen. I think one of the considerations I have when I'm bringing them on now claim is if I know this is happening to other people, or if my client knows this is happening to other people, and there's a way that I can prove that either through testimony or documents. So you want to make sure before you bring a Monell claim, you want to make sure that this is not a one-off anomaly that's just happened to your client. You really need to do some digging and make sure that it's happening all over that prison, at other prisons, and make sure that it is related to some policy or practice consideration that is pervasive.
Yeah, I mean, it's going to require a lot more discovery. It's going to require a lot more time in order to prove that there's in fact this broad policy or practice. On the other hand, I think that at least some people think that jurors are more likely to award a big verdict against a corporation than against an individual. So there's that. And of course, if you can prove that there really is this policy, then more people may get angry about what's going on. So I think that it's a judgment call. If what's happening in your case is that the doctor clearly just screwed up, didn't diagnose him properly, it persisted in a course of treatment which didn't make any sense and was obviously not working, then you have to ask yourself, why do I want to make this a broader claim? Why do I want to make my claim more complicated than it is? On the other hand, if it looks like the doctor is just following what they're told to do by Wexford, so for example, there's a whole series of hernia cases where Wexford had a written or unwritten policy as to when you should treat hernias and when you shouldn't. It may well be that the doctors were just following orders and following the written policies that Wexford did, and the real entity at liability here is Wexford itself. So again, you think about that as an option you have, but not something you necessarily want to bring. How about state medical malpractice claims? Do you have an opinion on that?
So there's some pros and cons to that. Your burden of proof is different. You don't have to prove deliberate indifference. As I mentioned at the previous seminar, you do have to have an expert at some point, at least for an affidavit, either at when you file the complaint or maybe at summary judgment. The thing is that you can get punitive damages against Wexford in these cases. And I did find the citation while we were gone, and I can put it in the chat for that case. So you could get a lot more money out of the case for your clients if it comes down to it. So I think there's pros and cons to it. Again, if you're gonna get an expert anyways, you might as well add a state law claim into your case.
And again, the other downside is if you should win the malpractice claim, but not the Eighth Amendment claim, there's no right to attorney's fees.
Right.
There would be a right to attorney's fees if you win the Eighth Amendment. So all things to keep in mind. I think that most lawyers will tack on a state medical malpractice claim, but there are reasons not to do so. There's a question in the chat or the Q&A about how you get these protocols that Wexford has. They protect them vigorously, I think is an understatement, saying they're trade secrets. There will be a protective order put into place, but there's no reason you shouldn't be able to get at least the parts of them that are relevant to your case. I've never had a judge who told me I couldn't have it, but they do have a attorney that has only strict protective order saying it can't be shared with anybody else ever. And we have attempted to fight that in a number of cases and have not won so far that dispute. Again, I don't know what Centurion's position is going to be, having just taken over. They may have a different position, they may have the same position, I have no idea. But Wexford has taken a very strong position that these are trade secrets, they're very valuable, they spend huge amounts of money developing them, and if their competitors got them, it would be a disaster. I think all of that is not true, but nonetheless, that is in fact their position. So you'll have to fight about it. We mentioned this briefly this morning, but it comes up even more often in medical cases as the requirement of a physical injury. In order to get pain and suffering damages, there has to be a physical injury. Now, that's not generally a problem in the medical cases because sort of by definition, something's gone wrong with the body, but it becomes a big issue in the mental health cases. Somebody can be suffering from a very severe mental illness without having any physical injury at all. The one bright note that I noted this morning was that the Seventh Circuit has said that self-inflicted injuries count. So whether somebody cuts themselves, maybe they bang their head against the wall if they're hearing voices in order to try to silence them, all those things would count as physical injuries. So it really is a question of talking very carefully to your client, not just about how they feel and how it affects them, but also have they had any sort of physical injury at all as a result of the lack of mental health care that they were provided. And finally, it's never grounds for dismissal of the case. It only is a limitation on the sorts of damages you can get. It only limits compensatory damages. It has nothing to do with nominal damages. It has nothing to do with punitive damages. It has nothing to do with injunctive relief.
I think also with this, with the mental illness, Alan, something I've been thinking about just kind of with the idea, like the idea of when we talked about earlier today, the exercise and solitary confinement. Be creative when you think about mental illness and ask your clients all the questions. Did they stop eating? Did they not move around as much? Those kinds of things that maybe aren't really super directly related, and we might not make the link between mental illness, but could be related and could satisfy that physical injury requirement.
Or like significant weight loss might count as a physical injury. In another context where somebody had refused to eat because of religious reasons, they weren't being given a religious diet and refused to eat the stuff on their plate that didn't comply with their religious beliefs, they lost a lot of weight, and the Seventh Circuit said that was enough for a physical injury. So yeah, I agree. Be very creative, and that's why it's a thorough discussion with your client as to exactly what's wrong with their body as well as their mind is really crucial in these cases. Statute of limitations is also an important issue here. The general 2-year Illinois personal injury statute applies, but it also imports all of the exceptions to the Illinois statute of limitations. So, for example, the continuous failure to treat rule applies here. So, in Mr. Rodesky's case we talked about earlier, he was under treatment by Wexford employees during the entire time. So even though it was 2 years past the time that his first doctor started treating him, everything was part of that case from the very beginning to the very end, because it was one continuous course of treatment by doctors all employed by the same firm, and they continued to fail to treat it appropriately for the entire 5 years, 10 years that this went on. Similarly, the discovery rule counts here. That is, prisoners are not, the statute of limitations doesn't start running until a prisoner knew or should have known that the doctor did something wrong. If you're still being, for all, prisoners are not doctors. So if a doctor says, what you have here is a X disease, and they tell you that for a couple of years, and it's only after this doctor's been treating you for a couple of years that a second doctor looks at it and says, oh my God, you don't have that, you have cancer. And that hasn't been treated at all. They screwed it up. Well, the statute of limitations doesn't run from the time that you were first told that you just had some other disease. It runs from when you were told that the doctor screwed up. So the discovery rule applies there. I talked about the mailbox rule this morning. That is, the statute stops running when the prisoner hands over the complaint to whatever prison officials they are who are responsible for actually filing it. Because again, the prisoner can't walk into court and file it themselves. And finally, there's some tolling going on. So during the time a grievance is pending, the statute does not run. And there may be other circumstances. For example, I had a case where defendants failed to identify an obvious defendant in their initial disclosures under Rule 26. And we only found out after we started doing paper discovery that there was another defendant who had not been, or another obviously relevant party who had not been disclosed. The court applied equitable tolling, saying since the defendants had the obligation to notify or to list all the people who were apparently involved, and they breached that duty, therefore it was not the prisoner's fault that they were late. So again, just because it's past 2 years, don't say, oh my God, there's no way in the world we can file this case, so this case has to end. There are lots of exceptions. So be creative, look at the statute of limitations, do some research under Illinois law, and see what you can find in the way that things are set out. All right, I want to talk about medical records now. As I said before, Illinois does not yet have electronic medical records. So they can be a trick.
I will note, Alan, they have changed somewhat. While they don't have an electronic medical records system, a lot of the records now are typed. And I'm not certain exactly how they do it, but they have like electronic forms and there's typing. And I would say about 50% of the more recent records. If you're going back a couple years, that's not the case. But it's not as difficult as it used to be.
Good. Is that, I know that was true on the mental health side. Is it now true on the physical side as well?
Yes.
Okay, that's why you're here. Nikki has done more of these cases more recently than I have. And certainly looked at more medical records more recently than I have. So again, this is Mr. Rodesky. Whether they're typed or whether or not they're handwritten, they all use the same format called SOAP, S-O-A-P. And that stands for Subjective, Objective, Assessment, and Plan. Subjective is literally what does the prisoner say is wrong, or what does the prisoner say in general. You can see here, this is an entry made by a nurse at 4:10 a.m. And what's the subjective? Good morning. That's what Mr. Rodesky said. So they wrote that down. What's the objective? They did the AccuCheck to see what the results were. You can see here that in this case it was 134, not a day when he was grossly out of compliance, and weight did not have such a high one as he needed. And then the assessment is what's going to happen. AccuChecks are going to continue to get AccuChecks and continue to get insulin, and the plan is to continue doing all of the same things they're doing. So that's what there should be an entry similar to that for every contact that the prisoner has with the medical personnel, whether it be by a doctor or by a nurse, or on the mental health side, whether it be a qualified mental health professional, social worker, or psychologist or a psychiatrist. They should all have the same basic format of SOAP. In addition to actually being the medical part, these are also, of course, useful to figure out who your defendants are, is who signed off on these various medical forms. That's when understanding the signatures can be difficult. You may have to use interrogatories to find out the names of the different people who who's treated your client because you can't read them. The judge may allow you to do a Rule 30b6, a sort of preliminary Rule 30b6 deposition in order to identify the doctors. All too often, we've gotten back responses saying all the names are in the records, which does me no good at all because I can't read them. So you can force, they have access to this better than you do. So again, I think it's really important to look at those medical records and try to figure out as best you can. Now, lawyers are not doctors. So obviously some lawyers have developed some familiarity with medical records and medical problems. I know Nicole has now looked at hundreds of these and probably should have a secondary degree in nursing from experience at this point. But if you don't have that kind of experience in-house, it may behoove you to hire somebody to interpret the medical records for you. I can give you the names of a couple of nurses who have provided that sort of consultation to appointed lawyers before. It's not for free. They do charge, but not as much as a doctor would. And they're not testifying experts. They're just going through these records and giving you a basic outline of what happened. And some sort of preliminary opinion is where you might look to see what went wrong. So again, I think that's really important, is to try to figure this out. How do you get these medical records, Nikki?
Meet myself. There's a couple ways to get. I mean, you can get them through discovery, clearly. That's maybe the slow way to get them, but you can also request them directly to the prison. There's IDOC has specific forms that you have your client sign, and you send those in to whatever facility they are physically at the moment. It doesn't matter where the treatment was provided; it's where they were at that exact moment in time, because the physical medical records follow the person in custody. So you submit these forms. I do know there's two different forms, one for medical care and one for mental health care. Like if you fill out other medical release forms for non-IDOC facilities, you have to identify what you want. I think you don't need to get everything because they will charge you for these records. So you want to be thoughtful about what you're getting. If you don't necessarily have an issue with getting the right medication at the right times, you maybe don't want the medical administration records, so you can not specify that. If you do need it, you need it, and you should make sure you get it. If you lab work or blood tests or those kinds of things are not important to your case, you may not need those records, so don't ask for them. So be thoughtful about what you're asking for. And as for mental health cases, there's two sets of records. There's the regular treatment records. If your client has been in crisis watch, which is they're being observed, the crisis watch logs are kept separately from the regular mental health records, and you may need those. We had a case where our client was supposed to be on constant watch, and yet she's still inflicted a very serious self-harm on herself, and getting those records showed us that no one was watching her. So you can find out who was supposed to be watching, who was supposed to be keeping an eye on your client and didn't, and dropped the ball. So those crisis watch records can be really important if it fits for your case. Otherwise, they're completely necessary, and you're going to get hundreds of pages of things that you're never going to look at again.
And I will say, often prisoners will have copies of their own records. Don't rely on that. It's a good start, but they generally are not going to be complete. There's no obligation, no penalty for the prison officials if they produce records to the clients, which they have the right to, just like you have a right to your medical records, but they're often incomplete. So I would never just rely on what the prisoner has. And even if you use the informal way of getting them by sending in a release, I would also subpoena them or ask for them through formal discovery. All too often we have found that they don't match up what you get informally and what you get by subpoena. And that may not be any sort of intentional misconduct on their part. I mean, for example, I've often had two-sided records where they only send one side of each page because whoever fed it through the copier didn't bother to flip them over. So again, I think it's really important that you also ask them formally through discovery. Besides anything else, that way you have a potential of going in and asking for sanctions against somebody if they didn't comply with it. Whereas if all you're doing is getting a copy through a medical release, there's nobody to hold liable if, in fact, at trial they come up with a piece of paper that you've never seen before from the medical records. So I think it's often a lot quicker to get them. It's obviously a lot quicker to get them from your client. It's often quicker to get them through the release process, but ultimately, I think you have to serve that subpoena and get a copy of them that way. I think it's also important to remember medical records, like other records the department creates, are not be all and end all. That is their version of what happened. So I think it's really important you go over these records with your client. Often the defense will say, well, we didn't know anything about that because he didn't complain about it. Well, that may be just because they didn't write it down, and maybe because they were enforcing the so-called one problem per visit rule. I've certainly had people come in and complain it, talk for 15 minutes about all the things that were wrong with them, and all that's written down in the medical record is he had a blister on his foot. So don't take what's in the medical records as gospel. They are the medical provider's narrative of what happened, and it's obviously going to be slanted towards the medical provider. So I think it's important to remember when you're presenting a case to the jury. It's certainly important when you are trying to evaluate the strength of a case. Don't assume that everything in the medical records is 100% accurate. It's a good start, obviously, and it's good admission against the doctors who wrote those records. But it's not the be all and end all. They shouldn't be taken as gospel, and you shouldn't discount what your client says just because it's not in the medical records. And what's in the medical records can be absolutely slanted. I've had lots of cases where a prisoner got beat up by a guard, went to the healthcare unit, said they told him everything that happened, and all that's written in the medical records is prisoner was fighting. Period. So it doesn't have any of the fact that he was attacked by guards and beaten the crap out of by a guard, just that he was fighting. And if that's left in the jury's hands, then it's going to look like he was the one responsible because he admitted he was fighting. So again, you got to go through those records in great detail with the client and make sure that it's accurate, and make sure you can explain to a jury or at summary judgment, wherever you're at, as to why these records are not the be all and end all of everything. Okay, moving on to the substance here of what you have to prove. Whether you're doing an amended complaint, whether you're getting ready for summary judgment, or whether you're just getting ready for trial, I think one of the key things to do is look at the Seventh Circuit instructions. Often people don't look at those Seventh Circuit instructions until they're doing jury instructions. I think that's a mistake. Personally, I like to look at the elements that are set forth in the jury instructions when I'm drafting my complaint, because it tells you what you have to allege in your complaint in order to state a cause of action. But certainly when you are dealing with your client, when you're taking depositions, when you're hiring an expert, you want to be aware of the steps that are required and that you're ultimately going to have to prove, and those are in the Seventh Circuit jury instructions. Seventh Circuit has a set of model instructions on its website, which are, I think, quite good for medical care. Defendants don't like them because they don't use the word deliberate indifference, which is what a lot of the cases use. Instead, they use it in more plain language. So I think I've always had the defense object to using the standard Seventh Circuit instructions, and I think 95% of the judges will just go with what the Seventh Circuit says, but be aware that there is this dispute going on out there. But nonetheless, these are the elements that you do have to prove. First is a serious medical need. Now, that isn't quite as daunting as it sounds. The courts have defined serious as meaning one a doctor says or should say needed treatment. So that can be most anything. I've only had, I think, one case ever where whether it was a serious medical condition was in fact disputed. And frankly, the dispute in that case was totally frivolous. So generally, if you're appointed to a case, then if you got through screening, then it's a serious medical condition. I have not run across any case where that's been a serious dispute because generally they've seen a doctor by the time they get to you, in which case, it's a low bar to meet that this is a condition the doctor needs to see. The harder part is the defendant's actual knowledge of the need or the risk of harm, depending on the sorts of case it is. So it's not enough, and it's absolutely immediately going to get you dismissed if you allege that somebody knew or should have known that this was a serious medical need. Should have known is a negligence standard, not an Eighth Amendment claim standard. So it's actual knowledge of the need. That's a subjective test. Did they, in fact, subjectively know that there was a serious medical need here? It doesn't mean they had to know exactly what the condition was. It doesn't mean they had to know the exact cause of the problem, but that there was a serious problem there they had to know. Also, a strong suspicion counts. It doesn't. They can't say, "Well, I wasn't sure it was there. I had my suspicions." That's enough. And it also, what I think of, and I think the Seventh Circuit used it itself. You can't use the ostrich defense. Like, I don't want to know. I didn't inquire because I don't want to know. Yeah, he came to me and said he had a lot of pain, but I just wanted to prescribe Tylenol. I didn't want to find out any more than that, so I didn't order any tests. Again, they can't just avoid having to provide medical care because it's a pain in the neck to figure out what's going on. That in itself is deliberate indifference, is failure to follow up and find out what's really going on. The second part that's objective is the conscious failure. That is, they had to have consciously said, no, I'm not going to provide X, which would solve the problem. Instead, I'm going to try Y, which I know isn't going to work. That's where a lot of these cases fall apart. The question is whether or not what they did is reasonable. In the real world, often doctors try conservative treatment before they go to more radical treatment. You don't start off with back surgery, you start off with Tylenol. And that's a completely reasonable thing to do. On the other hand, if they continue to do something over and over again, knowing it's not working, then that is great evidence of a conscious failure to take reasonable measures to prevent the harm. So again, if somebody has cancer and they keep giving Tylenol and it doesn't work, it doesn't do anything, they continue to get pain, it continues to get worse, then just continuing to do the same course of treatment, which is not working, is in fact evidence of conscious failure to do something. Final part of this is causation. That is, that what the doctor did wrong actually caused harm, not just that it was the wrong thing to do, but that it mattered. So I did a case before Nikki started practicing here, where that became the issue. So it was a horrible case. Somebody's out lifting weights. There was some defect in the bar that he was using, and the whole weight stack fell on his face, causing multiple fractures all over his eyes and nasal cavities and all that. Went in for very complicated, hours and hours of surgery to reconstruct his face. The outside surgeon prescribed certain antibiotics, sent those records back to the healthcare unit in the prison, and he didn't get the antibiotics that were prescribed. Period. They never prescribed. So he developed a very serious second infection, had to go a whole separate round of operations in order to dig out the infections, second whole set of very complicated, painful operations and recovery. Sounded like a great case to me. We got an expert, and he took a look at it and said, yeah, there's no question they screwed up, but it didn't matter because the actual infection he got was resistant to the antibiotics that were prescribed by the outside physician. And therefore, there's no causation here. He would have gotten the exact same thing and they given him the antibiotics because it wouldn't have covered this particular infection. So causation is something that you almost always are going to need a medical expert to talk about. We'll talk in a minute about the sorts of ways you can get around actually hiring your own expert, but causation is a vital part of that, which unfortunately pro se prisoners really can't talk about. They can't say that the failure to diagnose cancer made it worse. They can't say that the pain in my wrist was caused by the fact that they didn't splint it at the beginning, because those are expert opinions that they need an expert to talk about. Establishing that conscious failure or actual knowledge is often done not by direct evidence. I mean, you're going to, few and far between is a doctor going to say, oh yeah, I knew this guy was in severe pain and I decided to do nothing about it. They're not going to admit that. So how do you prove this? You prove it through circumstantial evidence, just like we prove lots of our cases through circumstantial evidence. And the key case there is another en banc decision by the Seventh Circuit, Petties, Petties versus Carter. It's at 836 Federal 3rd, 722. It's cited in the materials. And there, the Seventh Circuit goes through a long list of the sorts of evidence that would establish a prima facie case of deliberate indifference. Some of those are, how obvious was the risk? So while you have to prove that the doctor had actual knowledge, the way you can prove that can include things like how bad was it, how obvious was the risk. Now, the analogy that Jim Chapman used to teach this class always used was, suppose you got sued as a lawyer for blowing the statute of limitations. Could you get on, and you got on the stand and said, you know, I just had no idea there was a statute of limitations. I didn't know there was such a thing in the world. Nobody would believe you that you had no idea that there was a statute of limitations. It's something that every lawyer knows, the statute of limitations matter. So similarly, if a doctor got on the stand and said, oh yeah, I mean, I know that he had X, Y, and Z symptoms, and but I never connected the fact that that actually connected to such and such a disease. Well, if you have experts or it's common knowledge that those are actually sequelae of that disease, then a doctor is going to, that is circumstantial evidence that the doctor did actually know about it. So remember, the actual knowledge is what the jury has to find. You don't have to prove by direct evidence that he actually knew it. You can prove that it was such an obvious thing that any doctor in their right mind would have known. Any doctor who went through medical school would have known these things. So you have to distinguish carefully in your mind the difference between what the jury has to find and what the evidence you have to put on. You don't have to prove out of the defendant's mouth or by an admission from him or looking at the medical records that he actually knew what was wrong. All the things that even though they got the diagnosis right, eventually that he suffered pain along the way when they got to, but before they got to the obvious diagnosis. So continual pain, continual complaints of pain over and over again, and whatever they're doing didn't solve that problem, is a signal that most doctors would say, oh, gee, there's probably something else going on here. I should figure out what that is. Again, that's circumstantial knowledge, circumstantial evidence of actual knowledge and conscious failure not to take reasonable measures. Similarly, as I mentioned before, repetition of the same treatment that did not work can be, again, circumstantial evidence of the conscious failure to take reasonable measures. Again, the example I just used in terms of antibiotics, if they get sent out to an outside provider and the outside provider says to do X, Y, and Z, and they don't do that, then again, that is a circumstantial evidence of conscious failure or actual knowledge. And the final example they use is if the doctor is clearly approving some easier or cheaper treatment, which is very unlikely to work, that is good evidence that they're doing something for reasons other than medical judgment. And the same thing is true about security. Doctors are doctors, they're not security experts. So in Mr. Rodesky's case, for example, if the doctor had not ordered diabetic shoes, especially supportive shoes, because he said, well, security never would have approved those in the first place. Well, that's not the doctor's call. The doctor should have prescribed them, and not prescribing them means security never had a chance to weigh in on whether or not diabetic shoes were going to be allowed or not. So you should not, again, let the doctors off because of security reasons. That's somebody else's problem, not theirs. There's a question in the chat. What are the elements for a 14th Amendment claim? So the 8th Amendment is different than the 14th Amendment. And there's a whole bunch of case law until about 6 years ago, which said it's exactly the same. But then the Seventh Circuit made it very clear it's not exactly the same. Under the 14th Amendment, which remember applies to people who have not been convicted, who are in jail awaiting trial, you still have to have the serious medical need. But it's the subjective part here that's very different. It's more of an objective test. The test there is knowing the actual things that the doctor knew is what he did reasonable. So you don't have to prove the conscious failure to take reasonable measures, or you don't need that subjective part of it anymore. But you do have to prove that it was based on the actual knowledge he had. So if, for example, later on there's an X-ray which shows, in fact, he had a broken arm or a broken wrist or whatever, but the doctor didn't have the advantage of having that X-ray, then you can't say, well, the doctor knew or should have known about this objective fact, and therefore made the wrong decision. So it's not like a negligence claim where it's purely a question, did they follow standard of care? Regardless of what the doctor subjectively knew, it's a question of, given his actual knowledge, is what he did objectively reasonable? So it's a little bit of a twist. They try but the trial of these cases is very similar. In both cases, you're going to prove that, in fact, what they did made no sense from a medical standpoint, and therefore they must have been doing this for some other reason. They were overworked, they were trying to be security guards, or whatever the reason was, or just because they were trying lazy and want to try something that was inappropriate. All those things are going to be part of your proof, whether you're trying to prove deliberate indifference or whether you're not trying to prove a due process claim under the 14th Amendment. Does that make sense? Did I miss anything here, Nikki? Okay. There's a question here in the chat about an outside provider. Sorry, can you just a second to read this? So the question is, when is an outside provider covered by the 8th Amendment or the 14th Amendment? Tricky question. Generally, the answer is going to be no, because they are not stepping in the shoes of the state. Now, Wexford is a private company, and they are covered on the 8th Amendment because they are providing a vital constitutional function that the state is required to provide, and therefore they take on the same clothed responsibility to follow the Constitution as if the state was providing it with its own employees. On the other hand, somebody on the outside is really just in private practice, and they're not treating this prisoner any different than somebody else, any other patient they might have. It gets a little fuzzy where the outside provider has a contract with Wexford to provide care on an ongoing basis. There, they may become a state actor. A lot of that depends on how much control Wexford has over it, how much of their practice is devoted to patients who are in the prisons, etc. Plymouth Ambulance Company versus Rodriguez is the key case there. I don't have a cite for it, but it's a Seventh Circuit opinion, which goes through who is and isn't covered by the 8th Amendment in terms of outside providers. Some people are, some people are not. But remember, if they go to the University of Illinois in Chicago, which is the most common outside provider, it too is a state agency, and therefore it too is a government actor. So they have the same responsibilities as does Wexford or the Department of Corrections itself. All right, so how do you figure out what's going on? How do you get away without an expert? And these are all going to be things that you might be able to get away with, but I'm not going to soft pedal this. I think that in most cases, you're going to want an expert at some point in proceedings, not necessarily at the very beginning. And there may be exceptions to that, which we'll talk about in a minute. So how can you find some sort of expert opinions? Well, the obvious place is getting them from the defendants. And that can be from the medical records itself. The medical records themselves may say this person needs to get seen by an outside oncologist. And then nobody ever sends them there. That may be in and of itself an admission that, in fact, an expert is needed and they just didn't get it. So there, it may prove itself for the medical records. There may be emails along the same sort of lines. We talked earlier this morning about the problems of getting electronically stored information or emails in discovery. Just to be clear, medical records are not controlled by Wexford. They're controlled by the Illinois Department of Corrections. So they have to be cut from the Illinois Department of Corrections. If you have a state employee as your defendant, you can do the usual document request. If not, you serve a subpoena on the Illinois Department of Corrections for those records. Emails, however, are not part of the medical records, and they're going to be cut totally separately, and therefore they'll have to be separately either subpoenaed or ask for a document request. Again, depending on who you have as your defendants. But as I pointed out earlier, often emails are crucial here in terms of setting out what should have happened in the case. Doctor may send an email saying, I think we ought to do X, Y, and Z, and it gets overruled by somebody else, or just doesn't do it. So again, that may be the defendants themselves acting as an expert. Finally, there's depositions. Often there'll be cases where the deposition itself will provide you with the sort of expert opinion that you need. And I'll talk a little more about how that can happen later, but just to give you one example, an appointed lawyer tried a case about asthma. So it was a man I think it was at Pontiac, who had a severe asthma case, had an inhaler. As was true in most prisons, the inhalers are not allowed to be kept by the prisoner. They're kept outside of the cell. And of course, they can't just go to the drugstore and buy a new inhaler. They have to get it refilled by the doctor as a refill. So in this particular case, his inhaler was not renewed. And he had a severe asthma attack over the weekend and came close to dying, but did not, thankfully. And it wasn't until the following Monday that the doctor showed up again in the hospital, or came back again, and was able to, in fact, provide a new inhaler. So during the deposition, the lawyer asked, or on the stand, the lawyer asked the doctor defendant all the questions about asthma. What is it? How does it affect the body? How do you treat it? What's important? Why isn't it? What does an inhaler do? How does that help treat it? What happens if somebody doesn't get an inhaler? Asked all those questions, and the doctor answered them all honestly about what asthma was. So then the case actually came down to the question of whether or not the prisoner had notified somebody that his inhaler was in. And that becomes then a pure factual question, even though it's a medical case and medical expertise is important about causation and all that. They were going to get all of those sort of expert opinions from the defendants themselves. And the doctor said, well, of course I would have prescribed a new one if I'd known, but I didn't know. So it really came down to a question of fact as to whether or not this man who was dependent on an inhaler had just forgotten about it, or whether or not they'd gone and got it. A second way that you can get some sort of medical opinions is through learned treatises. 803.18 allows you to use learned treatises either to cross-examine a opponent, like the doctor. You can say, that this is, you can cross-examine and say, XYZ book says X, Y, and Z, and you didn't do that. That's not only good for impeachment now, but that can become substantive evidence. Question then becomes how you establish something as learned treatise. Often the doctor on the stand will not agree that this is something that is a recognized treatise. You could do that. You could ask the judge to take judicial notice of that. That often works. You can also do that through a notice to admit. And remembering, if they deny something that is obviously true in a notice to admit, the cost of proof then can be charged back to them. If you have to prove, if it's obvious that this is a treatise that's used in 90% of medical schools, and they refuse to admit that in fact it constitutes a learned treatise under the rules, then you might well be able to get the defendants to have to pay for your expert to prove otherwise. You might also be able to just get an affidavit from an expert. Even if you don't have a testifying expert, you might find your own doctor or some expert doctor who's not willing to testify, not willing to look at all the medical records, but he's willing to say, hey, yeah, I teach in a medical school, and this is a book that's used throughout the country. Everybody recognizes this as a learned treatise. So that may be other ways you can get this in. So again, keep aware of this. There is a provision in the rules for the court to appoint an expert as a neutral party to advise the court under Rule 706. That's a well-established procedure. Normally, however, the cost of that court expert, would be split between the parties. And obviously you don't have that money. So there have been an occasional case where the court has said, yes, I want to appoint an expert for my own use, and I'm going to order the defendants to pay for it. Or we're going to tap some court fund to pay for part of it. So again, that's something you want to think about, as to whether or not the court is willing to appoint one. That's generally not going to happen. It is a long shot at best to get the court to do it, but at least in some cases it has happened. So particularly if you have something that's complicated, that's something you may want to think about, as whether or not you want to make that motion. Finally, you can retain an expert. In the chat, which I guess got answered, there is a group of doctors called the Medical Justice Alliance, which is a group of doctors who apparently care about prison medical care. It's not just doctors, it's also a lot of medical students. They will provide opinions, not necessarily testimony, but at least opinions, perhaps an affidavit. Some of them are willing to testify about your medical care. I will say, however, it's kind of a long shot. There's a form you can fill out on their website to ask for their help. And then they send it around and see if there's a doctor or a medical student who's willing to take this on. Unsurprisingly, there are a lot more prisoners who have medical claims than there are doctors willing to give free advice. So it's a long shot, but if you end up hitting the jackpot with that, it's great. You have a free expert. Go for it. And frankly, the more compelling the case is, and I think the more widespread the problem is, the more likely you are to get their attention and get somebody willing to do it from that source. But again, it's an important resource which was not available until recently. I won't guarantee you at all that they'll provide somebody, but if you don't have the funds, it's important to go out there and get one. Finally, is that the court does have a small fund which you can use to reimburse, or in some cases advance, the costs of hiring an expert or any other cost you incur in representing your client. The general cap for that is $5,000, and the chances of you're getting a doctor who's going to review what can often be hundreds of pages of medical records, come to court and testify for $5,000 is pretty remote, I have to say. Most of them are charging more than that, but at least you can certainly get somebody to look at the records and give you sort of a consultation opinion for that amount of money. And that may give you enough to say, hey, this is a really good case. I'm willing to invest some money in it in the hope that we'll get a big verdict and I can get paid back. Or it may turn out the other way, that the reviewing person says, hey, I looked at these records and frankly, what they did seems pretty legit to me. I'm not sure you got much there, in which case you're not going to put out of pocket to get an expert. So again, those are all ways you might be able to deal with these kinds of cases without an expert. But in the end of the day, in a lot of cases, you are going to need an expert. But try to be creative and try to figure out ways that you can avoid getting an expert.
One thing I want to just mention that I don't know if Alan has mentioned before yet, but think about who you know as an expert. I know I've oddly have a lot of friends who are ER doctors, and I go to them and I'm like, hey, you guys want to do this for me? And sometimes I'll just look at the records and be like, there's nothing here. Sometimes I've had one who actually served as an expert and gave us a very, very discounted case rate, like friends and family rate. So think about the people people that are around you. Not necessarily people that do this for a career, do expert work for a career, but people who are practicing physicians, practicing mental health providers, who can give you some free or discounted insight in these cases.
Yeah, for years when the Uptown Fields Law Center had no money, we have a little bit more now. I relied heavily on a very good friend from college who, unlike me, who went on to go to law school, went on to med school. And she thought prisons were horrible places in general. So was willing to review records, would not be an expert, but was willing to go through records. Obviously, it was not, she had to do it on her own schedule. So it wasn't like I could get immediate turnarounds on anything, but it was free. She would do it for free. I know other people have used, there's one case where an associate at a big law firm used her father as an expert. The defendants moved to strike that as obviously biased, and the judge ruled that went to credibility, not to admissibility, and therefore was able to put on that testimony from her father. So, think about your old roommates, your friends, the people you play poker with, your own doctors. We had a case where Jim Chapman used his own ear, nose, and throat doctor as the expert in a case which was an ear, nose, and throat person. Didn't go to trial, but he did. He was willing to review the records and went on the record with an affidavit and then was deposed for summary judgment. So went all the way to trial, at which point it settled. So be creative about where you find your experts. Many firms may have a doctor as a paying client. That's somebody else you might think about if you represent a practice in some business dealings. For example, you might want to reach out to them and say, hey, I've got this pro bono case that I'm doing for free. Would you be willing to spend, a couple hours looking at this and talking over with me what's going on? And frankly, I found some of those ones who start off doing, yeah, I'll take a look at it, get so outraged by how bad it is that they will testify for you in the end. We talked about the outside consultating experts they send people to. Don't overlook them as experts as well. They are in many ways the best possible experts because they're not retained by you. These are people who Wexford contracted with or IDOC contracted with to provide medical care. So if they think that the care that was provided in the ICUC is terrible, then that's by far better than somebody you've hired as a hired gun to say the same thing. I know that a lawyer who took one of these courses before told the story of a hernia case coming out of Menard, where they sent him to the local hospital in Chester, the Chester Memorial Hospital, for outside treatment. And he talked to the outside doctor who was more than happy to testify. On cross-examination, the defense lawyer, not having taken his deposition, I believe, asked them sort of, why are you in the world are you taking this case on? Aren't they paying you a lot of money? And the doctor said, absolutely not. I'm here because Menard sends me all these horrible cases and they have to stop. They have to start providing medical care there. So on one hand, they can be your great experts. Many of them will talk to you informally. Some of them won't. But you can always take their depositions. The flip side of that, though, is if the outside expert says, no, everything was done right here, then you have to seriously think about whether or not you've got a case. Because remember, just having a disagreement between doctors about what the proper course of treatment here is not going to be enough to get you past deliberate indifference standards. So if the outside expert tells you, yeah, I think everything that the doctor did inside was absolutely fine, and the inside doctor, of course, says everything I did was fine, then you're going to have a very high hurdle convincing a jury that this outside expert said it was perfect. The inside doctor did exactly what the outside doctor said. How in the world can this be deliberate indifference? If that comes up in your case, then you want to have a serious conversation with your client as to whether or not there's anything at all you can do with this case, or is it going to be helpless? Okay, so we talked about depositions, and I want to spend a few minutes on how I like to structure my depositions of experts or of treating doctors. Nikki, you may have a whole different theory, so feel free to jump in at any time. I start off by thinking about those 4 different requirements that I have to do, the 4 different elements of it, and the goal here is to try to get as much as I can from the defendant's experts to prove my case. Maybe I can avoid an expert altogether, but at a minimum, at least I can try to narrow where the issues of dispute are between me and an expert I have to hire. So I don't have to hire an expert to talk about everything. We can just talk about whatever the narrow points of disagreement are. So I generally start off by just talking about the disease or the injury or whatever the situation is, not talking about my client at all. You're just like, I'm a dumb lawyer. You're a smart doctor. Please educate me about diabetes. Tell me what diabetes is, what effect does it have on the body, what's going wrong so you get diabetes, all those sorts of things. And of course, is this something you would recommend if they came to you in private practice that they should be treated for by a doctor? And generally, you can get all of that from the doctors. Doctors, like lawyers, love to talk about their own specialties, and particularly lawyers who don't know what they're talking about are happy to educate them and tell them how smart they are. So take advantage of that. Have those doctors go out there and tell you everything possible about the disease. Don't mention your client. None of this has anything to do with your client. You're just talking about the disease in general or the injury, whatever it may be that they needed medical care for. So that's my first bucket. And what does that prove? That proves you have a serious medical need. Great. What's the second thing I have to show is deliberate indifference. So how do I do that? I have to establish the defendant had actual knowledge. So I ask a whole bunch of questions about medical records. Again, not my client, just in general. Are medical records, and why are medical records important to doctors? Is it important that they be accurate? Is it important that you write down everything that happened? In the case of a doctor in the Department of Corrections, I always ask, what is the role of the nurses? Now, do you rely on what the nurses say? Do nurses have an obligation of writing things down in the medical records? Establish that nurses have a lot more contact with the clients than the doctor does, and therefore the nurses are the ones that are more likely to catch what's going on and have a better sense of what's going on with the client. And once you've established how important medical records are, because I've never seen a doctor who says, no, medical records don't matter. And if they say that, you probably have deliberate indifference right there. If they say, no, I don't bother to look at medical records, they're silly. That sounds like the ostrich defense, right? I don't want to know anything. So that's a pretty good evidence of deliberate indifference. And then the final question is, do you normally review a person's file before you talk to them? And it's sort of, at this point, this is a win-win question for you. If they say, yes, absolutely, of course I would look at those important records, I just told you how much they matter, then you have established that they have actual knowledge of everything in that file. If they say, no, I never look at records, then you've got evidence of deliberate indifference because they don't care what the records say. And they just told you how important they are. So that's a good way, I think, to really pin people down that they knew about the issue here. Now, causation. And again, this is something that a lot of doctors will give you. Using my diabetes case again, or Mr. Rodesky's diabetes case again. What happens if a prisoner doesn't get insulin? What happens if you don't get an asthma medication? What happens if you don't get the inhaler? What happens to your body? How does it change? Or in the case of a foot injury, how does diabetes affect feet? What is the physical manifestation that makes feet so important? How does that matter? Why does it have that? Is that why you treat it aggressively? Does it matter if you treat it aggressively? All those kinds of questions, which again, you're not talking about your actual client at all. And you're talking about what might happen if they don't get the sort of prescribed care that usually happens. And what is the standard of care? And again, you don't want to hire an expert. You don't want to have to be in a position of hiring an expert to talk about what the standard of care is. Again, most doctors are pretty clear and will tell you what the standard of care is. They'll have a reason why they didn't do it in this case, but hopefully they can at least establish what the standard of care is.
And with that, I think you also want to try and get them on the record that it doesn't matter where the person's at, where the person's receiving care, because a lot of, attorneys in these defense attorneys in these cases will say, well, it's prison, it's all different. But I think most doctors will agree that the standard of care is the same inside a prison or outside a prison.
Right. A broken bone is a broken bone, whether he's a prisoner or whether or not they're on the outside. A diabetic who has a foot injury is going to have the same risks in prison as out of prison. The body doesn't know whether or not it's in prison or not. It may have something to do with what the available treatments are that they can prescribe, but again, that's a security issue, not a medical issue. And get them to really focus on what the medical condition here is. And I agree with Nikki, whether it's a prisoner or not. And it's really useful to get them to admit that it doesn't matter whether or not the broken bone is by somebody in a prisoner or whether it's somebody on the outside. You still got to set it, you still got to do all the same things in order to get it to heal properly. So that gets you've got 3 of the 4 buckets filled now. You've got serious medical injury or serious medical condition, you've got actual knowledge, and you've got causation. So what's left is the deliberate indifference. So that's when you want to finally start talking about your client. They already established what should happen and what goes wrong. So then the question is, why didn't it happen in this case? And that's when you want to try to get this down as to a factual question rather than a standard of care question or a medical question. And again, if they say the reason I didn't prescribe a knee brace is because it's a security issue, then great. Say, okay, is what you did prescribe just as effective? Let's leave security aside. If this was a person on the outside, would a knee brace work just as well as whatever you actually prescribed? Or would surgery be preferred over what you actually prescribed? Get them to talk about the medical issues, not the security issues. And that's important because if it turns out they made a decision based on a non-medical reason, then that's one of the things that Pettis says is in fact circumstantial evidence of deliberate indifference, that they weren't making a medical judgment here. They were playing security guard, and that's not their job. Their job is to provide medical care. So I hammer them on what the medical reason is for standard of care deviation in this case, not something else like that. I think you can also do a lot of this research on your own before you go into these cases. So I say, yes, you should play ignorant, but you should actually know as much as you can. Back when I started practicing, that meant going over to the Northwestern Medical School next door to the law school and pulling out these textbooks, which I had a hard time understanding, and spending hours and hours there. These days, so much of this is available on the internet. WebMD tells you everything you want to know about every possible disease. Mayo Clinic has
the Mayo Clinic's website is really, really great for this. It's tons of detail, and I trust Mayo Clinic to tell me the truth. Sometimes WebMD is a little bit suspicious, but I would definitely say Mayo Clinic, Cleveland Clinic, they're both really good websites full of a lot of information.
And sometimes those internet sources can actually become proof in your case. There's a case, Rivera versus Gupta in the Seventh Circuit, where it was a very serious burn case. The prisoner found the prisoner was pro se, found a whole bunch of internet material talking about how infection was a serious issue when you have very serious burns. And the defendants didn't contest it. They didn't put anything in the opposition. So the Seventh Circuit said, yeah, they didn't have an expert to say this, but here's this internet stuff. It was not contradicted, and therefore at the stage of summary judgment, that's enough to get you to the trial. You want to do that research and figure out what's going on. Certainly before you hire an expert, but I would say even before you take your deposition of the other side. You can always use that to cross-examine them too. Say, hey, are you really disagreeing with Mayo Clinic on what the appropriate standard of care is here? Are you disagreeing with the Cleveland Clinic, or are you disagreeing with whatever source you can find? If you've got something more specialized, there are 8 million PubMed articles on everything in the world you could want on medical care, which get very detailed, and it's like going back to the old textbook days that I had. But it will give you more than you ever wanted to know about any disease in the world. And again, one of the things you can get from your medical school friends who want to say, no, I don't want to do that, maybe they can point you to a source that would provide a good overview of it. So you can educate yourself, even if they're not willing to look at medical records. So try to figure out different ways that you can do this yourself and learn as much as you can in order to effectively, particularly at this last bucket here, cross-examine people.
I have to pop out quick, Alan.
Okay. The other big issue that comes up is standards. So there are a whole bunch of different organizations which accredit or provide standards for medical care in prisons. New American Correctional Association is one. There is a ton of case law out there saying that the fact that you comply with the American Correctional Association standards is not evidence of complying with the Constitution. It's a very much a paper review rather than a actually how is care provided on a case-by-case basis. So even if the prison is, often defense attorneys will say, you haven't got a case, we were certified by the ACA last year. And you're like, yeah, it's totally irrelevant. There's a bunch of case law that says it's not. And it, frankly, it says nothing about how your particular client was treated at all. The other one, which I think is much better, is the National Commission on Correctional Health Care. Neither of these standards are publicly available. They all want to charge you money for a copy of them. So you want to look at those things. They could be evidence. Again, they're not going to be definitive because violating those standards also is not proof that they violated the constitutional standard. The constitutional standard is a lot higher, but it can be part of a circumstantial case, is that they didn't follow well-established national standards. Something else that particularly federal judges like to look at is the Federal Bureau of Prisons has its own set of directives on how various diseases should be treated. My friends who do a lot of litigation against the Bureau of Prisons say often those are terrible, but they're a lot better than the Illinois ones and can be used. And I think particularly with federal judges often are given more credit than they're entitled to, really, under reality. But again, if you can prove that the Federal Bureau of Prisons has a standard that says X, Y, and Z, and your client and your defendant only did X, then that's another piece of circumstantial evidence of what they did. Finally, there are professional organizations themselves. And every one of these specialties has a professional organization. The American Psychiatric Association, the American Association of Psychologists are two I dealt with most recently, but almost all of them. There's a Diabetes Association, which has very detailed standards on how you should deal with diabetes. So again, none of those are definitive in the sense that a failure to follow those outside regulations or guidelines is not the same as deliberate indifference, but it is again a piece of circumstantial evidence that there was deliberate indifference going on here. Also, remember you can use hypothetical questions even on direct examination. It doesn't have to be accurate as to what actually happened. So again, using my asthma case, you can hypothetically ask the person what would happen to somebody if, in fact, they didn't get an inhaler over the weekend. It may be a contested fact as to whether or not they, in fact, got that inhaler, but nonetheless, you can ask hypothetical questions of your expert or of the defendant doctors or nurses themselves. So you can get a lot of that there. I think that delays in treatment are also something that's a little bit different to get here, in that the evidence is often going to be a factual one. That is, how long did it take to see somebody? That's a much easier sort of proof to get, that somebody, sent in 15 medical requests and didn't get seen for 6 months. Those cases are pretty easy. Some of them are also obvious from defendants. You can get them. I mean, there's a horrible case out of it, which again is a Seventh Circuit opinion, where somebody had a very serious fracture to their arm, what's called a radial fracture, meaning it was twisted and therefore the bones weren't lined up anymore, and didn't get treated for about 4 days. And the excuse the doctor gave was that he was at a New Year's Eve party when this came in and had had way too much to drink to come in and do an operation at that time. Again, the court had no sympathy for that whatsoever. You have an obligation to provide medical care, and the fact that the only doctor you've hired happens to be out and partying at the time they should be providing medical care is not an excuse for not providing medical care. And that delay may not have made the break worse in the end, and you don't have to prove that, but it did mean that he lived through excruciating pain for 4 days that was totally unnecessary. If they'd had proper personnel hired, proper staffing levels. So think about your delay in treatment. Often people think, well, the delay didn't make any difference. Ultimately, he got treated and everything was fine and didn't make anything worse. But the delay itself may have caused him unnecessary pain and suffering. And again, that's something you want to really work with your client to figure out how he can testify as to how this went wrong. In a non-medical case, as an example of this, there was a case, I don't know what state it was in, not Illinois, where prisoner's basic complaint was that he had a lumpy mattress. Discovery showed that, yeah, he'd been complaining about this lumpy mattress forever. Discovery also showed that like 20 feet away, there was a whole stash of brand new mattresses that the prison had ordered. Just nobody had bothered to pass them out to the prisoners. So this is purely a pain and suffering case. No permanent damage. But the key was that the lawyer was able to get the prisoner to testify in great detail just how a disrupted sleep affected his life. It made him grumpy during the day. It made him short-tempered. It means he's gotten a lot more fights. He could describe in great detail about sort of rolling around all night long, not being able to go to sleep because wherever he lay, he had this pain in his back, poking through from this old mattress, and probably had 3 hours of testimony about how bad this mattress affected him. And in the end, got like $50,000 for a lumpy mattress. So, it may be obvious to you and me what happens with somebody, but working with your client to get them to really describe exactly what's going on with their bodies and how it affected them over time is really the crucial way to build these things up. Not so much expertise here. You're not talking about expert. You're talking about what the effect on the person was. So the ability to describe pain, I think, is something you often have to really work with prisoners on. Prisoners sort of have a real incentive to minimize that stuff when they're in prison because you don't want to appear vulnerable as a prisoner. So you're likely to say, I wasn't that bad. I can survive it. I'm tough. But that's not going to help you in front of a jury. So you really have to work with your client and get them to describe over and over again in as much detail as they can do, just how it affected them every minute of every day in as much detail as they can get. Because I think, the asthma case is my perfect example here. It turns out half the jury either had themselves had asthma or had a close relative who had asthma, and they could therefore easily sympathize with somebody as to what it meant when they didn't get their asthma medication for 2 days. Just how much you felt like you were dying if you couldn't breathe, if you couldn't get a deep breath because you didn't get your asthma medication. So those sorts of intimate descriptions by your client, I think are really, really important in order to figure out, how you can do this and how you can build up these damages. Because that's going to be a huge hurdle you have to overcome in all of these cases. That prisoners are not considered to be sympathetic people. And there'll be some people who you obviously want to try to get off the jury if you can, but just don't believe that prisoners should have right to free medical care. And therefore they couldn't care less if they didn't get medical care. And that's your job, is to overcome that sort of prejudice that there are against prisoners in order to get people to persuade that, in fact, yes, this is a meaningful and important thing that ought to be, that everybody should care about. And this person really and truly suffered, even if they're in prison. They're somebody who suffered terribly. I do want to talk about summary judgment. I think that particularly in medical cases, you will almost always get a summary judgment motion because all of the treating physicians will all say that what they did was completely appropriate and it was just a matter of medical judgment. So you want to really keep that in mind from the very beginning. Obviously, you want to be very careful of the local rules. You have to carefully follow all those contested facts and uncontested facts and material facts, et cetera. Make sure they're all laid out like they're supposed to be in the rules. But more importantly, you're thinking at the very beginning. And remember, you have to produce admissible evidence. So think about, as you're doing your discovery, these buckets you have to fill, and how at the summary judgment phase am I going to fill each of these buckets? How am I going to contradict the prison doctor saying everything I did was appropriate? The general standard I've set out in the written materials is set forth in the now old case of Celotex by the Supreme Court, but it's the same thing. Also think about affidavits, how your expert is going to give you an affidavit. Make sure you also follow disclosure rules. We're doing a case right now where the defendants never updated their disclosures, never disclosed any experts, and therefore we're going to trial with our experts against nobody. That's a great situation to be in, but it's the reverse of that is horrible. Make sure you timely update your disclosures and timely file your any expert reports you're going to have, including non-retained experts. So if you have somebody who's not retained, who's going to give an opinion, for example, the outside doctor is going to give an opinion, you have to make sure they're disclosed properly under Rule 26, or you'll be barred from asking them any opinion questions. Treating physicians are tricky. The rules generally allow treating physicians to testify as to what they did without being disclosed as experts, but really can't opine on whether or not what they did met the standard of care, for example, because that is an expert opinion which should be disclosed. So again, you want to be very careful to challenge those kinds of opinions by the defendants, and very careful to make sure on your own side that you properly disclose anybody you're going to ask for an opinion on the stand. There's also a recent case out of the Seventh Circuit, which I don't have the citation for, but it's within the last month, which talks about the duty of updating your complaint. Often a prisoner will start off with a bare bones complaint, and as you do discovery, you'll find out that there's a lot more to the story. If it's not reasonably signaled to the defendants in your complaint that in fact what went wrong is what went wrong, then you have a duty to amend that complaint. It's a terrible opinion from the Seventh Circuit where somebody did not update their complaint and found out that there's all kinds of problems with the actual doctor at the prison, that he had been accused of fraud in several other cases, and had in fact been fired or walked out of the prison by the warden, who thought he was doing such a bad job that he himself thought he shouldn't be practicing there anymore. None of that was in the complaint, and therefore the Seventh Circuit ruled that none of it was appropriately used at summary judgment because it had not been disclosed in the complaint, and therefore couldn't be relied on at all at the summary judgment stage. So as your case develops, make sure you go back and check your complaint, make sure that everything you're going to prove at the end of the case is actually alleged in the complaint, or you may be surprised at the end that you're not allowed to put that on. You guys don't have enough questions. I want to spend a minute. I'm going to hold and see if Nikki comes back to that one. I want to talk to some about how you can work with clients who may have a serious mental illness in terms of getting their fulfilling your obligation. That prisoners do still get the right to say what the case is going to happen, do get to make key decisions in the case. So Nikki has developed some good ways to do that, and I'm hoping she comes back again before we end. Instead, I want to talk about settlement, which should be later than that, but we're going out of order a little bit here. And some of this is going to be repetition from this morning, but I think it's particularly useful in the medical context. Here is that the timing is really important. You have to know what the case is about. You have to know who the defendants are, and you have to know, most importantly, whether or not the underlying medical condition has been resolved. The worst nightmare here is that you settle a case thinking that it was a concussion, for example, and there was a delay in treatment, and he was fuzzy for a few weeks, then it was fine. And that was the case, only to learn 6 months later that in fact he had a brain tumor which had not been diagnosed. At that point, he will have released his claims against the doctor, you would have settled it, and he'll be out of luck. So you want to make sure you really understand what's going on medically before you settle any case at all. You want to make sure there's no ongoing condition that needs to get treated in order to make sure whether or not you need to apply for injunctive relief as well. So think about all of that very carefully before you settle the case. And again, defendants are always like, I want to settle this right away. We don't want to hire experts. We don't want you to go to the expense. We don't want to go to the expense. let's just get rid of this case for, $5,000 early on in the case before we all put a lot of time into it. That can be a deadly trap, and I would strongly advise you not to do that, certainly until you've had somebody pour through the medical records and give you an opinion of whether or not of how serious the problem is here. And that may be yourself, that may be somebody else in your firm, or maybe an outside person you've hired just to give you an opinion on the medical records. But until you have some grasp of what's going on, I strongly urge you not to settle these cases too soon. It may come back on you to haunt you later on. That said, the client gets to decide. So if at very early on they offer you $5,000 and I'm like, absolutely not, I'm not going to take this, you can't say that. You have to go to the client and say, I strongly recommend against this, but there's always a chance you're going to lose this case later on, that you're not going to be able to get this money right along or later on. So make sure that you forward anything that you get, any offer you get to the client, and make sure that you have it in writing that they're turning it down, or you confirm in writing that they've turned it down, so that later on, God forbid, you should turn down a settlement offer, try the case and lose. Then your client comes back to you and says, oh no, you never told me about that. I had no idea I could have got $5,000 this. I would have grabbed that in a minute. So you want to make sure both you ask him and that you document the fact that you asked him and you had a discussion about it and he decided no. So I always write that down in a letter to him, keeping a copy, of course, in my file, so that later on when there's a dispute or I lose the case or get a less favorable settlement, I can prove to a judge or the ARDC, should they file a complaint, that in fact I did everything that my client told me to do. Understanding at the end of the day, if he wants to gamble, he can gamble. If he doesn't want to gamble, then he can grab the money. You should also think about how much money means to prisoners. Remember, the typical prisoner in Illinois gets $10 a month in what's called state pay for their job. So, $5,000 to us may not sound like a lot of money and may not be a lot of money for an injury. On the other hand, somebody's been surviving on $10 a month and has no outside family support. $5,000 can be a lot of money. And it may mean the difference between getting a TV or getting a good pair of shoes, or whatever it is they can do, or maybe sending some money off to their family to reimburse them for all the commissary that they put on their books over the years. Prisoners have all kinds of reasons why $5,000, which seems a little to us, may mean a lot to them. And therefore, you have to keep that in mind when you're having discussions with prisoners. Sometimes their demands are totally unrealistic. The other side is also true. That is that often prisoners value their case based on what they read in the papers. And of course, the verdicts that get covered in the papers are the big ones. So they say, well, this person got $10 million. I think my case is worse than that. I should get $10 million. Not understanding that there are 1,000 cases out there with very similar facts where they only got $1,000. So, I think it's really important to think about both sides of the equation. Is the prisoner really overvaluing the case, or are you maybe overvaluing the case given what the prisoner has to deal with? We also talked some about discovery. We talked about this morning in terms of conditions cases, but I think it's equally important for medical cases. Keep in mind demonstrative evidence, and that can be anything, but particularly pictures of the prison itself. This is on the left here is a picture of Pontiac segregation unit. On the right is Menard segregation unit. You can see just how tiny these cells are in the right-hand picture. And even if it's a case, say it's somebody has a toothache or my asthma case, you can imagine that being at home where you can get up and you can walk around, you go to the refrigerator and get a snack, and you go into your bathroom and take an aspirin, is very different than being stuck in a tiny little cell like this for 4 days with no asthma or splitting headache or whatever the situation is. So I think it's important that the jury understand just what your client was going through at the time, and therefore have a good idea of what the pictures can be useful in showing that kind of thing. Obviously, if you have a key medical record, you want to blow that up so that the jury can see it live. Be creative on how you can try to put visuals in front of the jury. Aside from anything else, it keeps the jury interested rather than just hearing testimony all day long. Particularly if it's a medical case with some complex medical stuff, there are jurors who have fallen asleep listening to experts drone on, and you don't want that to happen. So to the extent you can get visuals up there, which force the jury to open their eyes and look at stuff on the screen, it's always valuable. We're about to put on an expert who has written a whole bunch of stuff, and we want to put some of those learned treatises up on the screen. Little excerpts from, not the whole treatise, obviously, but a single paragraph. We're going to put up on the screen and have the expert read it so that the jury has something to look at, rather than just looking and staring at your client or at the witness on the stand. Oh, the other thing you want to be very careful of with settlements, sorry, I'm jumping around a little bit here, but is the payment schedule. If your defendant is Wexford, they generally will pay right away, meaning within a couple of days after the settlement issued. The Illinois Department of Corrections is much slower. It usually takes something like 3 months to get paid after you sign the settlement agreement. So you want to warn your client that there'll be a delay. Often clients want to settle the case because they need the money right away, and you have to be clear to advise them they're not going to get the money right away, at least not from the Department of Corrections. That's going to come in a couple of months' time and maybe longer. There was a period of time back under the Ron administration where, as you may recall, the state didn't have budgets at all, where it was taking over a year to get paid, sometimes as long as 2 years to get paid. You had some very upset clients during those times. So, I settled this case because I wanted to get money now, and here it is 2 years later. I would have been at trial and won and been over with if I hadn't settled. So it wasn't quicker at all. So you want to be careful to advise your client as to when they're going to get the money, not just the amount of money they're going to get. All right, well, I do want to talk about communicating with your client. As I've said before, the client gets to make decisions and certainly has a right to be updated regularly on what is happening in his case. Some of your clients are going to be seriously mentally ill. There's just no question about it. They may have either attention deficit disorders, so it's hard for them to focus on things. You may have schizophrenia, where they're listening to other voices in their heads. They may be severely depressed, so it's hard to process things. So the rules of ethics require that you provide them with as much say so in the case as they can reasonably put into the case, even if they're not able to really make decisions on the same basis as somebody else. So disabled clients have just as much right to control their case as anybody else does. Some of the strategies that we've developed in order to get people to focus is to break down questions in increments. So try to divide a big question into lots of little questions so that they can make very specific decisions that are very concrete. Rather than asking, do you want to settle this case? What numbers do you want? It's more like, what's your actual goal in this case? Is your goal to get treatment? Is your goal to get money? What would you do with the money if you got it? How much money do you need in order to accomplish your goal? And then offer some hypotheticals, like suppose you had $5,000 that you had at your hand right now. What would you spend it on? Would you feel you'd been cheated? So you can sort of break down these questions that are big questions about how much do you think this case is worth, which is going to be hard for very hard for many people to process, into much more focused, specific questions on what, in fact, it is that they have to decide. And breaking that down into simple questions makes all the difference in the world when you're dealing with somebody who either has intellectual disabilities, that is, the cognitive disorders, which frankly are vastly underdiagnosed in the Department of Corrections. The number of prisoners who had serious head injuries at some point in their youth is unbelievable. I've had many prisoners who have what look like behavioral problems, but in fact have almost certainly a traumatic brain injury, which simply are not discussed. You're right on time. I was just talking about how you deal with people who are cognitively impaired or have serious mental illness, what sort of strategies you use to try to get them to focus on the decisions that have to be made.
Yeah, one of the things I've found that is helpful for people that don't process, verbal information like we're all kind of used to processing is to use like charts and diagrams, talking to them, when we're talking about, the evidence, like just draw a picture with them in person and say, these are the things that are good, these are the things that are bad, and write it down so that they can visually see what we're talking about. I found that really helpful with a lot of clients. Even people that don't have any cognitive impairments. It's just helpful to kind of be able to see and put everything all in one place. Another thing is just being really patient. I mean, you may have to explain things several times, several different times. Sometimes getting someone else in the room from your practice who can explain things using different words in a different way can be really helpful because, we all get stuck in the way we think about things. And getting a different voice in the room who can kind of explain things in maybe a little bit different perspective or a little bit different way can make a big difference oftentimes too.
And the other thing I said was breaking down things into discrete decisions. Is that
Yeah,
what
and
you
I think that's kind of thing is like, you don't have to make all the decisions right now. I'm with one of our clients who had some real trepidation about filing a case to begin with. She had really serious mental illness. She self-harmed in a way that caused her to be blind. So she had a lot of trepidation and fear, and we just kept talking to her and kept, talking about like the little things, like and really, talking about the consequences of different decisions, the potential outcomes. And when she wanted to talk about big things that maybe we didn't think were realistic, her biggest fear was that the economy would crash and all of her money that she got in settlement would go away and she wouldn't have any. But we just have to meet the people where they're at and acknowledge that maybe what they are saying is true and maybe it will come to pass, and like let's talk about what we can do to protect you against these things even if we don't think it's a reality. So I think I mean that's the phrase I just used, meeting them where they're at, I think is the most important thing for our clients.
And the other thing you did in that case, which I thought was very effective, was find somebody on the outside who they trusted.
Right, we brought
And
her
you
mom
obviously,
into the
yeah,
conversation.
and let's be very clear, of course, you can't do that without the client's permission.
Right.
You can't disclose anything to a loved one. And that's a hard line you have to draw. You'll often get phone calls, and whether or not it's a medical case, you'll often get phone calls from somebody saying, "Hey, I'm this person's wife. They asked me to find out what's going on in the case." The answer is I cannot talk to you without a written permission from my client.
Right.
And that's true for this. But if you can get that written permission to talk to somebody on the outside, sometimes that outside person can be very useful. Like Nikki, you're about to talk about her mother.
Yeah, so her mother came in. In this case, she actually got some power of attorney over the client because there was going to be a significant amount of money, and our client just did not feel comfortable. Generally, I advise clients not to give away any of their rights, either by a power of attorney or guardianship. I want them to retain as much autonomy as they possibly can. But in this case, it was appropriate. And it was really helpful having her mom there because our client already had a distrust of the legal system. And having her mother there agreeing with us and what we were saying was incredibly helpful. The other thing is, particularly when you're talking about settlement, is putting out the numbers for them, what they're actually going to be getting, what this breaks down for a year. If you do a yearly, if you get $10,000, that means for the next 10 years you get $1,000. But with bigger amounts, it changes. If you have this large amount and it gets invested, this is what you could end up with. So you're actually getting more money over time. So kind of breaking that down. I know we're not financial advisors, but sometimes you can use your real life experience to kind of help a client who maybe has never had any money to kind of understand how this works.
Yeah, I think that's particularly important. We have a very serious case with a big number out there. People have a hard time who have never had more than $100 at any time. Trying to understand what $1 million looks like is really difficult for somebody to do. So again, those are the sorts of strategies. Break it down as to how much does that mean. Every month that means you'll get a check. If you invest it in an annuity, that means every month for the rest of your life you'll get a check for $10,000,
Right.
whatever the number ends up being.
I think
Um,
that, and I think that's even more important when you have a little bit smaller amounts. When it's, I mean, everyone knows $1 million is a lot of money, but maybe $50,000 is a lot of money. When you're not paying rent and you're in prison, $50,000 is still a lot of money, and that can help like recenter the client in what is meaningful to them.
in terms of that final point about what's meaningful for them, it's also important to talk about things that are not money.
Right.
So particularly in an issue where there's an ongoing issue about treatment, What they really may want is to get treated. They don't really care so much about getting money as they want to make sure that whatever this problem is finally gets dealt with. Now, often this is a trap that we often fall in, or the defendants try to put us into, is say, yes, as long as you agree, we will agree to send this person to an outside consultant, in return for which you have to dismiss the case. I would always highly recommend our clients say absolutely not, because there's no guarantee that they're actually going to do what the outside consultant says they do.
Right.
So why would you dismiss a case if you send it to an outside consultant? The outside consultant says, yeah, they grossly fucked up. Excuse my language. Technical legal term there. Then you've dismissed the case, and that's not going to help anybody. So I would never do that. On the other hand, you might want to think about moving for a preliminary injunction to get them a outside consultation. And that has been done fairly often. Now, the same rules apply to any other preliminary injunction. You have to show a likelihood of success on the merits, and an inability to compensate this through money instead of getting actual equitable relief. But nonetheless, in a case where there's a serious medical condition, if you have some evidence that there's a serious medical condition and some evidence that in fact it's not being treated appropriately, it's something that a judge might well order, saying, okay, this clearly does warrant an examination by an expert. Therefore, I'm going to order Wexford or the IDOC to arrange for an outside consultation, not as part of the case, but as part of their ongoing treatment.
And sometimes you don't need to even raise at that level to go in front of the judge. For example, in Mr. Rodeski's case, after he had his amputation, he was having a hard time getting his prosthetic devices updated. And I just sent an email to the attorney for both attorneys for the defendants on the case and say, hey, this is happening. He doesn't have his prosthetic devices. They need to be updated. Please make this happen, with the veiled threat that otherwise this is going to come into the case when it wasn't originally part of the case. So sometimes you don't even have to raise it up to get to the court's attention. Just a strongly worded email to the opposing counsel can get action.
And similarly, I've occasionally had judges say that we're not going to have a big fight about preliminary injunctions, and just turn to the Wexford lawyer and say, hey, this seems reasonable. Can't you just send him out for something? And the Wexford lawyer will say, sure, we'll get that done. And you're obviously taking a risk there. If the outside consultation says everything is fine, your client has, okay, it's not helpful to your case, but at least you know that now, rather than 6 months down the road after you spend a fair amount of money on this. So yeah, do think about, and sometimes what they want is not medical care at all. I mean, in some mental health cases, for example, what they really want is a TV, because otherwise they can't read, and they just sit there and stare at the walls all day long. And if they had a TV in their cell, it would improve their lives tremendously. Now, obviously, you're not going to settle for a TV if it's a really serious case, but there are maybe cases where that is a reasonable settlement. So you again, talk to your client right away about what they really want out of this case, and what things matter to them. On the other hand, if it's a really serious case and they want a TV, you can say, hey, a TV costs $300, and if you get a $3,000 verdict here, then you can buy a TV. So we don't have to settle for just a TV. But again, if they want non-monetary things, that's something is at least worth exploring. I will say that one thing everybody wants is a transfer to Dixon, because there's a rumor that Dixon provides top quality medical care. First of all, it does not. Medical care at Dixon, if anything, is worse than it is at many other prisons. So you can disabuse them of that as a factual question. And second of all, it's something the department is loath to do, because everybody wants to go to Dixon. Aside from the else, it's closer to Chicago than most other prisons, and therefore it's easier for families to visit. So your chances of getting that is small, and the chances of your client being dissatisfied when they get there are very high.
And one way that I've kind of addressed those issues with clients is I just come right up and I'm like, there's no good prisons. I can't in good conscience advocate for you to be transferred to a different prison, because I know that none of them are good. And that usually kind of fixes the conversation.
Yeah. And if you get that kind of question, again, I'm available for any of those sorts of questions about settlement or about the underlying case. This is not a one-time thing. You can come back to me. My email is in the written materials, and you can feel free to reach out to me at any time, and we'll set up a time to talk about what's going on. You can also check out our website, uplcchicago.org, which is has all of the information from our two big medical class action cases, mental health case and our physical health case, including a ton of reports from the court-appointed monitors. Again, the case I talked about earlier, which lays out how you can bring a Monell sort of claim against the private corporation, talks at great length about how you can and can't use those monitor reports. The short version is they're really, really good for notice purposes, so that you can prove that the IDOC or Wexford was aware of the problem. They're not going to be so good on causation, to show that, in fact, the shortcomings that are system-wide are what caused your client the problem. There's a lot more detail in what I want to say is a 20-page opinion, but it lays out lots of details as to how you can use those medical records, or how you can use those expert reports.
And I put the citations to the Seventh Circuit opinion in the chat. So if you guys have access to the historical chat, you should be able to find the Dean citation.
They can't see the chat.
Oh, then never mind.
But if somebody puts in a question, what's that citation, you can type it in. And it's also in the written materials somewhere, but I can't find it, and I'm looking for it. Dean. Sorry,
Yeah.
I got it here. Dean versus Wexford Health Sources. Oh, I'm sorry, I don't have the whole citation. That's the one I said was a November 10th, 2021 opinion. Do you have the official site handy, Nikki?
No.
No. Okay. Anybody should be able to find it. Oh, is Wexford covered by insurance? Good question. Yes, but up to X number of dollars, and I don't know where that X is, they're self-insured, so they pay that out of their own pocket, and then beyond that, they're covered by insurance. So there is absolutely insurance, and they have their own risk assessment people, so it's very much like litigating against a private company. They have their own ways of figuring out how much a case is worth and how much they're going to settle for, based on the sorts of verdicts and settlements that have gone in the past.
I do have the citation for Dean now.
Thank you.
It is 18F 4th 214.
And in terms of the settlements and insurance coverage, we have the Uptown People's Law Center is now collected, although it's now a couple of years out of date. All of the settlements and verdicts against Wexford and its employees, which if you send me an email, I can send you a link to have access to that database. And it's broken down in ways that will help you sort of narrow by the particular sort of injury that you're dealing with. Any more questions? We went through this a lot faster than I thought we would. It may give you back an extra hour in your day. Okay, I don't see any questions coming in. Any final words you want to say, Nikki?
No.
These are rewarding cases, I have to say, and in some ways they're really easy cases in the sense that finding problems in the IDOC medical care is pretty easy because there are so many of them. On the other hand, they're somewhat difficult because you are dealing with lots and lots of medical information, which generally lawyers are not experts in. So I think they're fun cases to do. They're really important cases to do. And the more people you talk to who have medical issues, the more horror stories you'll read. And some of them are just horrific. I didn't really talk about the role of security guards, but often think about not just the role of medical provider, but also the role of security staff. They may well be an appropriate defendant. We talked about Rodesky at the beginning. You ended up getting a verdict. You ended up settling with a private medical provider, but getting a much larger verdict against the Illinois Department of Corrections for security issues. That is not providing him with an ADA compliant cell, etc.
Yeah, you can always settle with one party. I mean, traditionally, the attorneys representing Wexford are better prepared, have greater resources than the Attorney General's office. And Wexford tends to have deeper pockets and pay out a little bit more than the state. So sometimes it is strategically smart to settle with Wexford early on, get your client some money, get the more experienced attorneys off the cases, and then just move ahead with the Department of Corrections, keeping in mind the open chair problem that you often have when you dismiss one set of defendants.
Right, and beyond resources, as was put in the question and answer here, Wexford often hires the expert, and IDOC relies on the expert. And if you settle with Wexford, all of a sudden IDOC has no expert at all, which happened in your case.
Correct. Which saved us money because we didn't have to use our expert.
Right. So it's a way of avoiding experts altogether. Yes, set off is a big issue. The question then is whether or not it is one indivisible injury, or whether or not there are different injuries that are caused by different people. So yes, there is absolutely an issue about set off. Defendants always argue that everything is one indivisible injury, and therefore any settlement you get has to be deducted from any verdict you get later. We've done pretty well at arguing that often they're separate. The medical person may have like different sorts of injuries. So again, the fact that he had his leg amputated is different than whether or not he had to walk up and down the stairs all the time. So those are two separate issues.
I don't have, for as far as wondering if we take our depositions of the doctors, treatment providers prior to the 30B6 depositions. And for me, it kind of depends on the case and what I need to know. If I basically know the process and how things go, I don't necessarily take the 30B6 first because I know what questions to ask. If I'm coming into something completely new and I don't know how the process works, I may consider doing the 30B6 first.
Yeah, the problem in doing that is you only get one of them.
Right.
And therefore, if later on in the case you figure out that there are really some policy questions you need to ask, and you've already blown your 30B6, you may not get to ask them. So again, be careful of that. A good question is, what if you have other prisoners as witnesses? You have to send subpoenas. Yes, but I want to question why you're doing it. Generally, they will be very cooperative witnesses. So I always go and talk to them first and see what they have to say. And then if you need something to lock them in, do an affidavit, which they can sign. And I have never deposed a prisoner ever. It just gives the other side an opportunity to cross-examine them, because prisoners will not talk informally to the AG's office.
Right. Just remember to put them on your disclosures.
Right. Make sure you do the disclosures. But yeah, I have never subpoenaed. The other thing is, if you're going to do that, not only do you need to send a subpoena, but you also will need permission from the court. You're not allowed to depose. Neither side is allowed to depose anybody in prison without court permission. And you'll have to arrange for the prisoner to actually be there, so that you'll probably need a writ from the court or something else to have that prisoner actually be present, who's not a witness. So obviously, you're not going to go to their cell and have a deposition there. So if for some reason you have to depose another prisoner, which I would highly question whether it's a good idea or not, there'll be a whole bunch of hoops you have to go through to arrange that.
And just so you know, like, though talking to witnesses, you can speak to witnesses on legal calls or legal visits. So you can talk to them, and you should speak to them on a closed line, not in the general open telephone lines.
And at least
If you have problems with that, email Alan. We've got some great case law on the issue.
Right. You may get some pushback. Some prisoners don't. Some prison litigation coordinators make you put in the whether or not they're your client. And I think that there's good law on that that's not the rule. Any more questions? We have covered everything we had in our outline, believe it or not. Okay, there being no more questions, then I think that we will end this a little early. You will shortly get a survey response. It's scheduled to go out at 4:30 when this was supposed to end. So you'll get it then, and please fill that out. We change this every single time. We do these presentations based on feedback we get. So don't be afraid to make criticisms or suggestions on how we can do this better. We're always trying to improve. So we really appreciate your being here, really appreciate your taking on these cases, and thank you so much for giving us some feedback when you get the survey.